Hello and welcome. My name is Latavia Alexander. What you will hear shortly or be watching is a recording from a legacy conversation session that was hosted on August 5th by myself and Shawnielle Predeoux. During this presentation, I should say redacted presentation, we cover the importance of establishing legacy, what estate planning is, the value in planning ahead, and just some important things for you to know and be mindful of. I do hope that you enjoy and find the information helpful. If you have additional questions or would like to retain either of us to prepare your estate plan, our contact information is included at the end. Just a bit of a disclaimer up front. Although we are both attorneys, this is not us giving you direct legal advice. This is just general information. And so what we will cover is going to be big picture. There may be differences for your specific situations, but just want to make sure you keep that in mind. Okay. So as someone asked about, or just talking about legacy, I'm a person that I like to look up definitions, and so I would say Webster's actually says that a legacy is a gift by will, especially of money or personal property, essentially something that's transmitted by or received from an ancestor or predecessor. And so one of the things is trying to shift the perspective in the conversation around estate planning to say, what is my legacy? I'm taking the time to build it, to create wealth, or just to, even if you're not looking at it just from the standpoint of money, of just kind of building up what your name is, your reputation, your brand, and making sure that when you pass away, that will continue and it doesn't die with you. So just an overview of some of the things that we'll cover tonight. Just why is estate planning necessary? Cover some of the documents that are common, such as advanced medical directive, power of attorney, a will, trusts, and then just other things that you need to know, and then what to do or expect during the probate process or after someone has passed away. Um, excuse me, Shawnielle, I'll let you take this one.
Okay. So basically, estate planning is a process where you allow your voice and your choices to be heard with respect to who you leave your assets to, um, how you want your legacy to go on, and in some cases, it can be to minimize the effects of taxes. So we'll talk about like taxes a little later. But with respect to estate planning, it is generally for everyone. A lot of people think you have to have a lot of money in order to engage in estate planning, but that's not necessarily true. So, say in some cases, for especially some of the younger people, if you've moved away from home and you don't really live around your family members or your parents, you may want to engage in estate planning to ensure that you have someone available to make medical, that you trust to make medical decisions on your behalf, who could quickly be contacted if something happens to you. And in doing so, you may name your parents or family members, but you'll have contact information that can be used so they can easily be reached. And then you could also name friends, close friends and whatnot that you trust to do so. If you have small children and not a lot of assets, your major goal of estate planning may be to ensure that your children are provided for. If you do engage in estate planning, you're able to choose which guardians would take care of your children if something happened to you. Basically, if the initial guardian would be the other birth parent, if one exists, is living. If not, it'll be the person that you name in your will. And that prevents your child from going into foster care. It also prevents people from trying to fight over who gets the child and who can take care of the child if they do have a lot of assets. Um, and then also your purpose for estate planning may be to leave a legacy. You want to make sure that your children are taken care of. So in doing so, you can establish a trust for your children so that they receive assets over time and they'll have money for college, and then they also have a nest egg to support them and get started to reach their endeavors. It may also just be to ensure that your home, passes to your children, and that can be done in different ways, either by will designations or can be done through some non-probate estate transfers, such as deed preparation, where you add a child to your deed and change the ownership from just regular, like fee simple, to joint tenants, in which case it would pass to the survivor.
Excuse me. So, so growing up, I used to always hear if you fail to plan, you plan to fail. So that is just like I said, keep that in mind. And to the point made earlier about for those, I would say for those of us who are getting started in your career, or even just those who are younger, where you may say, I don't have any assets, or I don't have a lot of assets. Some of the life documents that would be helpful to have in place, it would be an advanced medical directive or a power of attorney. So an advanced medical directive is essentially, or in some states it's called, or some places call it a living will or a healthcare power of attorney. But essentially it's a written instruction on how you want your healthcare to be handled when or if you're no longer able to take care of yourself or make those decisions for yourself. It gives you the ability to appoint someone as a healthcare agent. I would say majority, if not all of the states, have some type of statutory form that they've created. So that way it's uniform, and you can get it. You can go online and get it. Most doctors' offices have either that form or a version of it, and so that you can complete it. And it's something that you want to. It helps you think about what you want done in terms of your health care. If you specifically in thinking about end-stage illnesses or terminal diseases, of if you're in the hospital, if you think about, hey, someone who's been placed on life support, do you want them to do any and everything they can to keep you alive and to sustain you? Or you're saying, no, don't do anything, let me go. So there's various options that you can select and designate what you want to have happen. And you are also able to identify the person or a backup person or a group of people to be your agent. With that one, you would want to make sure that you sign it and then it's witnessed by two people. For a power of attorney, that is for when you are alive. Most of the times people think of power of attorney in the sense of someone handling finances for a elderly parent or a family member who's no longer able to make those decisions or just needs some assistance. But the power of attorney, you can give someone, I would say, carte blanche ability to make decisions on your behalf or in your name, or you can limit it. But it's something that, as helpful as it can be, I always advise people to think twice before they execute a power of attorney, because if someone has it and they abuse those powers, it could be very detrimental for you. For example, they can make purchases, they can enter into contracts, they can sell your house. That's something that has happened. They can clear out your bank account. Those are things on the negative side. But at the same time, if you do need assistance, that's an area that they can help. With the power of attorney, it does have to be signed and witnessed by two people. In Maryland, it does have to also be notarized. And I know that some of you are in North Carolina, so just a note about that is, in North Carolina, in addition to being signed and note in front of a notary, it also has to be registered in the county for most of the banks to acknowledge it. Why, I do not know, but it's North Carolina. So,
right. And having a power of attorney and advanced medical directive prevents you or someone having to go to court and obtain guardianship over you. So you have guardianship of the person, which is basically a person who seeks to make medical decisions for you and decide where you stay. and guardianship of the property, which is over your, finance and assets, which is the financial power of attorney. If you don't have those documents in place, one, a guardian could be named that you don't want. So in some cases, if you're receiving benefits from like a state agency, if you're like Department of Aging, they could actually name the state agency or a representative of the state agency to be your guardian. Also, it's kind of it's more expensive than not having the documents to have to do a guardianship proceeding, because you have to pay legal fees for an attorney, and then you also have to pay the $185 court filing fee in order to do it. And the process is generally not quick. It generally takes like 6 months or more before the guardian gets established and the court renders its decision. In certain cases, you could request an expedited hearing, but there's no guarantee for that.
And yes, there's nothing quick about the guardianship process. Okay, Shawnielle, I'll let you cover or talk about the intest. What happens if you were to pass without a plan or a will?
Right. So basically, if you don't have a plan and you die without a will, then all state laws designate who to receive your property. So generally, it's close family members. So if you have children and no living spouse, then your living children or living children and the children of a deceased child, your grandchildren of a deceased child, would inherit and split everything. If you do have a spouse but no children, grandchildren or parents, then your spouse would inherit everything. Basically, if you have a spouse and children who are minors, then the spouse gets half of your property, and then the children get the other half. If you have no minor children, the spouse gets the first 40,000 plus half, and the children get the other half, and so on and so forth. So if you have a spouse and parents but no descendants, generally, if you've been married more than 5 years, the law just changed in October 2019, where the spouse gets everything if you've been married over 5 years. If you've been married under 5 years, then the spouse will split your property with your parents, and they'd inherit the first 40,000 and 50% of everything else, and your parents would get the remainder. And in cases where you have no close living descendants, then they go above and they look at your grandparents and their heirs, so like your aunts and uncles and their living children. If you don't have any of those, then eventually your property could go to like the state. If you're receiving like Medicaid for nursing home care, it would go to the Department of Health and Hygiene. Otherwise, it would go to the Department of Education in the county where you live. All right, so sometimes you may not want your property to be passed by intestate succession. So say, for example, if it does pass that way and you have siblings, it would go to equally to full siblings, half siblings, and some you may not have, any relationship with. So families are complicated these days. So a parent could have children by someone else, and they're technically your siblings, and under intestate succession, they'd be eligible for an equal share with your siblings you were raised with. And some people don't want that. So if that was your case, you'd want to make sure you establish a will for that purpose so it doesn't happen. And then also, some people take care of children that aren't really their legal children. And if you want to leave property to them, it's easiest to do that in a will. There is something called, if you do have children that you did not legally adopt, that you didn't birth, but you consider them to be your children, there is a process that, a court proceeding would have to be started so that they could inherit from you. But again, they'd have to get an attorney, have to start a court process in order to be considered a child to inherit from you, and to get your property. But if it's your intent that they have it anyway, then you should establish a will to make it easier and less costly.
Yes. So, with all of that in mind, I'm just going to kind of take a moment to kind of check in with those of you who are listening, hearing all of those things. And for those of you who have not created an estate plan yet, what are some of the things that are stopping you or have stopped you? Just in terms of talking about an estate plan, a will. A will is essentially your opportunity. It's a legal document that addresses what you want to happen when you die. I like to say it's your last chance to say what you want done and how you want things handled for yourself. You're able to say, this is what I want and how I want it to be done, as opposed to the state having a say in it. Because we showed you all before, each state has laws set up where it says if you pass without a plan, we've created one for you and we dictate what goes where and to whom. And I would say, once again, this is for Maryland, but in most states it is the same, in that the requirements for a will to be valid is you have to be 18 years old, at least 18 years old, and have the capacity to enter into a contract, essentially of being of sound mind and no undue influence. And most states require you to have two witnesses. Sometimes I've had people ask if they have to have it notarized. That's not a requirement. Some people will add the notary or the notarization just to, I guess they feel like it makes it more official or add some extra weight to it, but it's not a requirement. And the other documents are trust, and Shawnielle will tell us about those.
Right. So another document that can be used in estate planning is a trust. And basically, a trust is a separate entity, like a business entity that holds title to property. Trust, there are different types of trust. So a trust can be an inter vivos trust or a living trust. And a living trust is established while you are living. And it also comes into being and is used while you're living. Depending, for an inter vivos trust, it can be a revocable trust where you could, if you're the person who created it, you can terminate it at any time and then transfer the property back in your name. Or it could be an irrevocable trust, which means it can't be changed, but you can still benefit from it during your lifetime. So one of the benefits of the two is that an irrevocable trust provides some asset protection with respect to protecting your property from creditors. So if you do have a profession where you could be, or even a business where you possibly be subject to liability, you may want to establish an irrevocable trust to protect your assets so your house couldn't be taken if you were sued for malpractice, or you were sued in relation to your business and someone was awarded a large judgment. But with the inter vivos trust, generally, if it's a revocable trust, so you have control over it and you can dismantle it at any time. Basically, with that, it's for tax purposes, it's kind of disregarded. You'll still, say you put your home in the trust, and so it's titled in the name of the trustee, which is generally you, if it's a revocable living trust. You would still take the deductions for any home mortgage interest and property taxes on your personal 1040 tax return. Generally, with an irrevocable trust, at that point, it's considered a separate legal entity in most cases, and it would require its own tax return each year. And the tax rates for income are a lot higher. So generally, if the income from the trust exceeds $15,000 and that amount isn't distributed to beneficiaries, then it could be subject to a 37% tax rate, which is a lot higher than the individual tax. So some uses for trust, a lot of people say they would like to establish a trust to avoid probate. So if you do have property in a trust and you die, then you generally name a successor trustee, and you also name beneficiaries so that the property would automatically pass in accordance to the document. At most, if you had a home in a trust, the successor trustee could, if the trust would end and the property be distributed to your beneficiaries at your death, the trustee would just be responsible for having someone draft the deed for, say, example, the home, into the names of your heirs, and then transferring it to them, and the trust would be terminated at that point. Another reason, some people say they want to use a trust to avoid probate so they don't have to go through the expensive probate fees. In some states, probate is really expensive and really lengthy. Like California, New York, and Florida, there, the probate process can last years, even like 5 to 10 years. In Maryland, the process is relatively simple. So for example, if everything's already established, they know what you have, they can distribute it. It can generally be over with in less than a year. If there's property to sell, as soon as they can sell that property, then the probate would generally end. The fees are also established in law, so it's not as costly. So basically in Maryland, if you have assets up to, say your main asset is your house, and the assets are under 500,000, then the probate fee would be $500. The maximum probate fee, if you have like assets over 2 million, the probate fee would be 2,500. From 2 million to 5 million, and then if it's over 5 million, it'd be 2,500 plus like 0.2% of your assets above that amount. But the fees are pretty set, and then you would also have attorney's fees, but they're also set by statute, and they're generally under like 3%, whereas in Florida and things, the fees are a lot more expensive. For example, I had someone, her mom left her bank account to her in her will. The bank account had like $500 in it, and that was the only property that needed to be transferred. And in Florida, to open up the estate and transfer the property that to her, it would cost like $300 to get $500. If there were still $500 after bank fees. But anyway, in that case, there are some processes. For example, if a account goes dormant, there's something called dormant bank accounts, and there's escheatment in all states. Whereas if you have a bank account or you have property that belongs to another person and there's been no activity in the bank account for a while, or say you have, you worked a job and then you left that job and started working somewhere else and you moved and they couldn't get the last check to you, under the escheatment process, it would go to the state would hold on to that money, and then you would get it if you found out about it and filed a claim for it. And I told her, you might as well just wait for that process, because otherwise, by the time you hire an attorney, which they required, and pay that $300 fee, the money's gone. But back to trust, another reason for trust is disability planning. So say, for example, if something happens to you, if you don't have the power of attorneys, like the financial power of attorney, a trust could kind of be used for that purpose, because the trustee can step in your place and then handle your affairs for you with respect to paying your bills if your bank accounts are part of the trust property and things like that. Also, with respect to disability planning, the #1 payer of nursing home care in the United States is Medicaid, which is a needs-based program. So generally, if you have Medicare, because you're over 65, they'll only pay for nursing home care for the most part up to 60 days. After that, if you need long-term care, you either have to pay for it yourself, you have to have long-term care insurance, or you have to qualify for Medicaid and they'll pay. And then there's also like a waiting period to actually find a place, because the slots are few for people who receive Medicaid, excuse me. So with respect to disability planning, under Medicare, you can only have a certain amount of assets in order to qualify for it. So if you know that you have a health condition, say dementia, you have early dementia, so it's very likely in 10 years or so you would need nursing home care or assisted living care, then you may want to put your property into an irrevocable trust and transfer it to your heirs, so that one, you could qualify for Medicare, and two, your property wouldn't be subject to like a Medicaid lien. I'm sorry, I kept saying American. Medicaid. It won't be subject to a Medicaid lien. So generally, if you do own a home in your name, a lot of people say they're scared that the state would take their property, and that's because they would have Medicaid. Generally qualify for Medicaid, you can have a house that's valued at like $500,000 and you'll still qualify. They won't take it at that point. But when you die, if there's not an exemption, then they will place a lien on that home and it won't go to your heirs. It may have to be sold to pay that Medicaid lien. Or in some cases, Medicaid, they pretty much will work with people. Your family members could refinance the home and pay them, or they could enter into a payment arrangement and pay Medicaid so they don't lose a home. But that's a problem, that you could try to avoid by either transferring the property early in trust or by also establishing, as I think, for either transferring the property early in trust. It could also be used for asset protection with an irrevocable trust, as I stated before. You can, under most state laws, including Maryland, there is a provision you can include in the trust. So basically, for property that's in the trust, if there is a creditor, they can't take that property that's in the trust. They can only get property that's distributed to you. So again, if you would be subject to claims due to your job or something, or even if you have a lot of rental property, because I have people that ask about trust for that, and they don't want to be subject to liability if something would happen, somebody would get injured on their property. They may want to put their property in a trust so they won't lose everything if something happens. And trust can also be used for time disposition. So if you do have children and you want to leave a legacy for them, a lot of people, their main asset is life insurance. So if you have a $500,000 life insurance policy through your employer, you might not want your children to receive that all at one time. So one thing you can do if you do establish a trust, especially a testamentary trust, which is a trust that's established in your will and it comes into being when you die, and because it comes into being when you die, it's irrevocable because you can't change it. You can establish a trust for your children that would, if they're minors, it can pay for their care while they're minors. It can also be used to provide them with gifts and things, or you could give them like a set allowance each month or each year, and then they could get the property that's in the trust at certain ages. Some people do like at 25 they get a part, at 30 they give another part, and then like at 35 or 40 they get the remainder, and to ensure that they have assets and that they're mature enough to be able to use the money in a wise way, that you spent your life develop, either saving or paying for so they can have it.
Okay. So,
all right, and then like you've heard the phrase, there's nothing certain in life but death and taxes. That is true. If we're living, so far as we know, there's no immortality. So at some point you're gonna die. And even after death, taxes survive. So if you do have taxes at your death, there is a lien on your assets for that. So if you have back taxes, one thing your personal representative who handles your estate has to do is file tax returns, and they either have to pay or settle outstanding tax due if you do have assets. If you die with no assets, then nobody gets paid. So you just send them a notice, it's an estate without assets, and that dies with them. People are not responsible for paying their relatives' debts when they die. A lot of companies, credit card companies and things, will call a spouse or a family member, child, and tell them, oh, they're dead, but why don't you pay this amount? No, you're not responsible for paying for their items, except for taxes. If they have property, because otherwise you won't get anything. But basically, once that's done, taxes are certain. So you do have to come up with some type of plan to either pay them off if you do have to have a house and you want that passed to family members. You have to come up with some method to pay them off as you would with the Medicaid lien. Then you also have like gift tax is a tax that applies when you're living. So basically if you give gifts to people, They are subject to tax if they're over certain amounts. So there is an annual exclusion where you can get $15,000 to any number of people each year, and it's not subject to tax. If this you give over 15,000, if you're married, you can double it and give 30,000, because you can use your spouse's 15,000. But in order to do that, you have to file a gift tax return and your spouse, I mean, to say that you're splitting the gift with your spouse. Otherwise, the IRS could come after you later, and demand that your estate or whatever pay gift tax on assets. The gift tax rate is really high, it's 40%. Also, for gift tax, you have a lifetime annual exclusion. The lifetime annual exclusion provides to get, I mean, it applies to gift tax, it applies to estate tax, and it applies to the generation skipping transfer tax. So right now for 2020, that annual exclusion is 11.58 million, which is really high, and there's hardly anybody who pays that. So they said, for example, in 2019, there were only like 30 people with businesses that paid, well, I'll say state tax. But the exclusion is used for all of them. So, say for example, one thing that gets people in trouble, if you do add a child to your deed, or if you do transfer your home to your children because you anticipate having to needing Medicaid to pay for nursing home care in your future, then you do have to file a gift tax return and use part of that gift tax exclusion. So it's not subject to the gift tax. If you don't do that after you die, if the IRS could come after your estate and provide an assessment for gift tax if that gift tax return isn't filed and the exclusion isn't used. And either, at that point, you'd have to get an attorney to try to settle it, but then that's going to be a cost, or you have to pay the tax. So generation skipping transfer tax, that comes into play while you're living, and it can also come into play when you die. But the generation skipping transfer tax, if you provide money to if you give large gifts to your children or grandchildren, you have to skip one generation. So you have to skip your children, and it would have to go to grandchildren or great grandchildren. Say you establish a trust to benefit your grandchildren, it would be subject to generation skipping transfer tax. And in order for you not have to pay that tax, you would have to use part of the lifetime exemption, which of course right now is really high, 11.58 million. So when they passed the tax law changes at the end of 2017, what it did at that time was to double the lifetime annual exclusion. So technically the amount is only half of that, and it's going to drop back down to that in 2026 if nothing happens. So there's also rumors that if we do have another Democratic president, which is likely, in Congress, that the gift tax, the lifetime exemption will be reduced to $3.5 million, so that more people have to pay it again, because that's one way of getting income to support other programs. So the estate tax comes into play when you die. So if you die and you have your gross assets in your estate will be compiled if they're above the exemption amount, and the exemption amount can be reduced during your lifetime for gift tax or generation skip and transfer tax. So whatever amount you have left, if your assets are above that amount, you have to pay the estate tax on that. And the estate tax on that is high. One reason why they established the estate tax was to keep people like the Rockefellers and things, Vanderbilts, who established really large fortunes and would pass them on to their children and grandchildren. And they paid very little tax, because most wealthy folks can avoid tax by putting their assets in tax preferred items. Like a lot of them invest in capital assets. So they may receive, they might sell stocks and things which are considered capital assets, and their maximum tax rate will only be 20%, which is the maximum capital gains tax rate right now. So they could have, they could get income of millions and millions of dollars during the year, and their maximum tax rate is 20%, whereas the middle class working person who is making 150,000, 200,000, they're going to pay taxed at 37% or something. But wealthy people were able to avoid tax because they had money to pay people to do that. So in order to, one, kind of level the playing field and to keep them from building a lot of wealth that wasn't taxed, they established the estate tax so that their estate could be taxed after death. And there's still ways that people can get around it through estate tax planning, but for now, because the exemption is so high, it's generally not necessary. Like one thing, when Aretha Franklin died, she did not have a will, she did no tax planning, and they said she had, I think it was like 60 million to 100 million in assets. So her assets, I mean, her family lost a lot of money because they had to pay that 40% estate tax. So, people with those things, and then assets that will continue to accumulate under the estate, like performing artists and things, will continue to sell their property. Is very, very beneficial to have an estate plan. Even if you're a budding writer, songwriter, book writer, you never know what's going to happen. So it may be something that you want to establish so that you can pass your assets on to your heirs and not give a big gift to government.
Yes, you mentioned Aretha Franklin, and she and Prince are part of the reasons that I feel like we have to talk about this more, because
right.
I was shocked and disappointed in hearing about both of them, but specifically Prince, just because of how much emphasis he put on ownership and owning the rights to his music and so many other things while he was alive. So to hear that when he passed away, he had no estate plan was just like, how did you all miss that? And all of the legal battles that you all went through in terms of making sure he owned his music, the rights and everything else, and how selective he was about things. It's just, how? So those are two extreme examples of what happens when you don't have a plan, and how much money is given to the government, essentially. And I would say, I guess, an example in the opposite, I would say Marvin Gaye's estate. Mm-hmm. To my knowledge, there was some level of estate planning, or even Michael Jackson, but in the sense of, if you ever heard of, I know it was a few years ago when the song Blurred Lines came out, if you heard, there was a litigation because the Marvin Gaye estate sued the makers of the song Blurred Lines because they said that it was violating copyright. And they were able to do that in the name of, because they are the heirs, and they have maintained and they are keeping a watchful eye of their grandfather's estate and his legacy. And so they were able to sue on his behalf, and they did end up they ended up winning that suit.
They did.
They came close to settlement, but that went on for several years. But that's just, like I said, those are some examples of the reasons you should.
Right. And also with Prince, he had like a couple of full-blood siblings that he had relationships with. And then his dad had a lot of other children who were his siblings as well. And because he had no will, they got their share as well. So, and I'm pretty sure that wasn't his intent, because he said he had one sister that he was really close with, and he probably would have wanted everything to go to her, but because he had no will, all of his siblings got to split his property. One final thing, like I didn't mention inheritance tax. So inheritance tax is another death tax. Some states have it, some don't. So with a gift tax, that's generally a federal tax. Some states will have a gift tax during lifetime as well. For states that don't have a gift tax, they generally have an inheritance tax. And inheritance tax is a tax on transfers after death. And it's basically to any transfers to non-exempt persons would be subject to a 10% tax. So say you own a home and you leave 50, exempt persons would include your spouse, your in-laws, your children, grandchildren, stepchildren. Non-exempt persons would include aunts and uncles, girlfriends, because a lot of people live together, don't want to get married, and if they leave property to their girlfriend, including a retirement plan, which is a non-probate asset, but it would be subject to inheritance tax, that person would have to pay 10% of what they inherited. So that's something to be aware of.
Okay, so we've covered quite a bit. And before that, just one other thing I thought about as we were talking about examples of what happens when you don't have an estate plan. I don't know if you all remember, it was back in I want to say late 90s, early 2000s. It was in the news about a woman named Terry Schiavo, where she'd been in an accident, ended up on life support, and I forget if it was that I want to say, essentially, it came down to it was a battle between her parents and like her significant other about whether or not they should remove her. And I'm sorry, it was her husband and legal guardian, but it turned into this battle of one side wanted to leave her on life support, the other wanted to take her off of life support, but there was nothing that was established that specifically said what her wishes were ahead of time. And so it turned into this very long, drawn out, and public battle about what should happen. And so I use that example in the sense of for those who say, I don't have a lot of assets or I'm not sure. Um, but it's a reminder that and I would say this year is also a reminder that you just never know what's going to happen and life is short. And so to keep that in mind, so at the very least, having that advanced medical directive or the power of attorney, having things like that in place for the unforeseen life instances, because life is stressful enough as it is, and then when you're gone or if you're in a position where you can't take care of yourself, you don't want to that just adds on to the stress, as well as the money for those that you leave behind. So, in terms of planning and just thinking about, most people don't like talking about death. It's uncomfortable. You bring it up, oh, I don't want to hear that. Why you want to talk about this? But as it's been stated already, the two things we know that are certain are taxes and death. So it's just a matter of you just have to have the conversation. And the best way to do it is to just have it. But for those of you or for anyone who is still a bit apprehensive, not sure, you're wondering like, okay, how do I have the conversation? How do I bring it up? These are just some things, want to cover some things to keep in mind, and ways to prepare in terms of, I like to say, have the conversation with yourself first, whether it be an audible conversation or you're just writing things out, to think about what you yourself want, what your wishes are, and then if for those who have children, if they're not adult age children, maybe you're not necessarily having that conversation with them as explicitly, but you're having conversation with other loved ones about what the plans are. So some things to think and keep in mind of just identifying what your goals are. For those with children, one of the goals I imagine would be that, okay, if I were to pass before my children, who do I want to take care of them? Where do I want them to live? How, who's going to provide for them? And all of the things related to that. Loved ones, if you have parents who are older, or if you yourself are older, just in terms of those who own homes and the Medicaid conversation about potentially needing to put someone in a nursing home. What do we want? Like, what is that going to look like? And what can we do to prepare? Like I said, children or those with special needs, making sure that you have thought about how are they going to be provided for, cared for, financially, in addition to just kind of that emotional care as well. Identifying what your assets are, thinking about whether or not you want to be buried or cremated, because with both of those, it does require some arrangements are required in both of those. Some require a little bit more than others. Do you want to donate your organs? Do you want to donate your body to science? That's become a more popular option. I know I've seen some things where people, I guess you're cremated and the remains are then planted and you become a tree or other things. So that's some things to think about. Do you want to, what do you say?
Cremation jewelry for family members, where your ashes will be used to, instead of being set in an urn, they can be used to create a piece of jewelry.
Yes, I have seen that, like where some people, they maybe like a necklace and they're wearing it, so that way everybody has a little piece of you. Um, I don't believe that I want that, but hey, to each his own. Charitable contribution, you know, I want to leave money to my church, to my school. People create endowments, or you want a foundation to be created in your name, or a scholarship fund. Uh, those are just some examples. And then insurance policies do not pass through the will, and not everything here is something that will pass, that could pass in a will. But these are all different things that you want to think about and be able to, if you don't have an answer to it now, start thinking about what your answer would be, in terms of, okay, if I were to end up in a vegetative state, what do I want them to do? If I'm temporarily incapacitated, who do I want to be the person responsible for making my decisions? And what do I want to have happen while that's taking place? Um, and I guess that's another note about the power of attorney and the advanced medical directive. You could have them, when you execute them, go into effect right away, or you could do something called a springing power of attorney, where it's, you create, say I create it today, but it does not go into effect right away. I could set a specific date or an event that I want to have the power of attorney be initiated. One example is, excuse me, I want to have the power of attorney go into effect once a doctor declares me incompetent, but not before then. Or, and I've seen some where it goes into effect when a doctor has declared me to be incompetent temporarily, but if at any point I regain consciousness, or the doctor says I am now competent, then it's then revoked. So it can be as general or as nuanced as you would like it to be. Um, but I would say one caution against those is, when you add the different caveats to it, is that sometimes people say, I want to have two doctors, or I want to have a specific one, and then you have to wait until that certification is done and then proven for your power of attorney to go into effect. And depending on where you are or what state, it could add, it could just create more complications than you anticipated, because you were hoping to have something, you just, hey, it's there. Well, like I said, these are just some things to think about. So we've touched on this, but just some other things, like I said, they are not covered or do not pass through a will. And that would be property or things you put into a trust. And that could be either where you created the inter vivos trust, as she mentioned before, or you do a testamentary trust. Life insurance proceeds, if you have retirement accounts, investment accounts. Essentially, if there's an account where you can list or specify a beneficiary, then that's not something that is going to be covered by your will, because you're saying in that policy, this is who I want to get the proceeds from this. Uh, if there's securities in a transfer on death account or payable on death bank account, property that you own with someone else, where you are joint tenants by the entirety. An example of this is for those who are either I will say specifically Maryland and North Carolina. When you purchase a home, you are married. The default is that you own the home as joint tenants by the entirety, with the right, joint tenancy with the right of survivorship. And so what that means is, when one person passes away, their ownership automatically transfers to the other owner. So if you own a home and it's titled that way, that's not something you really have to worry about specifying in your will, because that's going to automatically transfer. However, if you own it where you are the sole owner, or you own it as tenants in common, where each person has an equal share ownership, then that's something where you want to make sure that you identify in your will, or whichever document you create, I want my share of ownership to go to this person. But one of the things that you can do is also register the will in the county that you live in with the Register of Deeds in your county. So that way, in the event that it's lost or no one can, if there are people, you didn't tell people where you kept it or they're not able to find it, or in some situations, people are able to find a copy of the will, but they don't have the original. Most states are not going to allow you to enter a copy into probate, but one of the things that you could do to kind of safeguard against that is register it with the county register of deeds. So that way there's one on file no matter what. The one thing to think about or remember with that is if you do register it, if you make changes, make updates, any changes, you need to make sure that you also follow up to update the copy that the county has on file, because what you don't want to have happen is I registered I did everything, I got my plan, I registered my will, and then maybe 5-10 years later, I have some life changes, I change my will, but I forget to update it. That could then create another challenge when someone they go to enter it into probate, and then the county's like, well, no, we have another one, and now we have conflicting wills. So those, like I said, some other things to think about. And we've touched on some of these things, but just some other things to think about in terms of what happens after a person has passed away. Like I said, in terms of they've decided they've said they want to be buried or cremated, you want to get in touch with the funeral home and then getting a copy of the death certificate, and making sure you go through, and then going through that process. In terms of life insurance, contacting the company to notify them that the person has died, and then going in accordance with what the policy says, or if they'll want a copy of the death certificate or any other documents that they require for that process. You'll work with them. Same with pensions, retirement plans, is contacting the administrator and notifying them of the death. With them specifically, they're only going to speak with the beneficiary. And you'll want to get copies of the death certificate. We have here at least 10, because you'll need to send everyone listed here, and then even sometimes depending on how the bank account was titled, or even if someone was renting, if they live in some type of assisted living facility, or even if they were renting an apartment or renting a house, you'll need to give copies of the death certificate to multiple entities to verify that the person has passed away.
Right. And it's a lot easier to obtain after death from the funeral home, and it's cheaper. It may only be $10 from the funeral home. If you have to get copies later, you have to get them from the Department of Vital Records, and it's a lot more expensive. And you also have to prove, that you're entitled to receive it. So you have to be a personal representative, or you have to be an heir with a specific need. All right. And one thing, like with respect to funeral homes, in some cases, if someone died out of state, either in a nursing home, or like on vacation or something, you would have to contract with multiple ones. Usually you contact one in your state, and they would contract with a funeral home in the other state, and that funeral home would pick up the body, embalm them, and then prepare the death certificate to be sent to you, because the death certificate is in the location that they died in, not necessarily where they live. And then the person, like my dad died in, well, my stepdad, who was technically my dad, who raised me, he was my dad, he died in Chicago. Then they have to arrange to fly the body back to the state that they're going to hold the funeral in, and the remaining part will be done there. And with respect to life insurance, if you're a federal employee, one thing that's very, very important, when you submit beneficiary designation forms, if they are rejected by your human resources department, please keep that original somewhere, because they'll reject them for the simplest, stupid reason. So for example, it could have like a cross out on there. Say the pen wasn't writing properly, so they wrote over the number a couple of times so it would be dark enough. They would consider that a crossover, and they'll reject it. but it's still legally sufficient, you know, if it meets the requirements of the law and has like two witnesses and whatnot, and can list the errors and the percentages that add up to 100% and whatnot. So even if the department, you know, if the HR department would reject it, if you do have the form that they send, because they'll send it back. If you have a copy of that, you could actually send that to the insurance company, or you could file an action in court to require them to accept the beneficiary designation if the HR department has rejected it. And the federal government is the worst, and it takes forever to get your benefits too. So if I have to say this, so if you do want your, you know, if you do expect your children, or you know that family members will need money right away, then you do need to make other arrangements so that they can get the money right away. It generally takes 3 to 6 months for the federal agencies to pay out. And it's not because it takes that long, it's just because a lot of times the paperwork sits on someone's desk and they don't want to do anything with it, whereas other companies will pay out in like less than a month. So that's another take home.
Yes, the government, it's, you know, hurry up and wait is something I've often heard. So yes, so just in terms of once after, those are things to do in terms of after the person dies, and then if you'll cover just kind of the probate process in general.
Right. And one thing, like we said, I think we mentioned it before, you know, if the person does have bills, like credit card bills and whatnot, you don't have to pay them if they're only in their name. If you do have secured property like a house, then yes, the heirs do have to pay the mortgage. Or if you have a car, they have a car in their name that you want to keep, you have to keep making payments on that. But for unsecured debt like credit cards and things, the creditors have to file a claim within a specific period of time. If the estate is generally the earlier of 6 months after the person dies, or 2 months after the personal representative, or now the register of wills will do this. You have to pay the fee, publishes a notice of appointment in a local newspaper. So if you open up the estate right away, then they have less time to file a claim in the estate. But you only have to pay the bills in which a claim was entered. If you have assets. If the estate has assets.
Yes, I see the raised hand, but we have just like 1 or 2 more slides, and then we'll just cover questions. I think we've covered everything in terms of probate. One thing I guess I just wanted to make sure that I point out with this is probate. The process is something you can do it on your own. And most states and counties have some type of guide or DIY packet that they've created if you are doing it by yourself. But I strongly encourage you or anyone to at the very least have a conversation with an attorney who handles probate and is familiar with the county in which you are going through that process, because there are a lot of small things that could be forgotten, and that if you forget them during the process and then it comes back up later, then you have to reopen the estate, and then that could create, cost more money, more time. So just make sure that you are working with someone to go through that process, and make sure that you're addressing everything that needs to be addressed while the estate is open. And so just some additional things to remember, kind of also in terms of the probate process for those, if you own a home, or if the person who created the will, they have left the house to someone else, one of the things that you have to make it does not happen automatically. You have to actually go through the process of changing the title on the deed, changing the name on the deed of the house. And if that's not done, where I would say it has come up in a negative aspect is if, say, grandma passed away, she left the house to grandchildren or even to the children. They've been living in the house. There was still a mortgage on the house, or even if there was no mortgage, property taxes. life happens and you get behind on payments or you get behind on property taxes and the house is now up for foreclosure or facing foreclosure, um, if you, in the situation, if there is a mortgage, the mortgage company is not automatically going to transfer the mortgage into the new owner's name or the heir's name. So that's something where you have to go through the process of qualifying for financing yourself,
No.
in some instances. But
Only if you refinance.
well, yes, if you have to refinance,
Continue to pay the mortgage, and they don't have to go through the mortgage approval process.
right. Um, and then I will say there are some mortgage companies that because I had a case where someone had to prove that they were an heir and going through that whole process, but that of course happened because they got behind. So like I said, just some things to think about in terms of making sure you go through all of the steps. Um, if you have a spouse and you get upset, they do something for whatever reason, you decide, hey, I don't want to include them in my will. Most states, there is a provision that prevents you from doing that because even if you did leave them out of the will, they can file for what's called an elective share. You can disinherit children, but you need to, one thing to be mindful of is if you are doing that, it's advisable to make sure you at least acknowledge all of your children in your will and then specify that you are choosing to leave certain ones out. Um, Beneficiaries on various policies, making sure that anytime there's a major life change, you're updating it. An example would be someone who's married, they get divorced and then remarry, but they forgot to take their former spouse's name off as a beneficiary when they pass away. That if there's been no change, the former spouse is going to be the person who receives the proceeds of that policy. Um, we said before, checking your documents, reviewing them every few years or after any life or financial changes, and making sure you're updating and changing names on the title or deed of property. So that is, I would say that's the gist of it. But if there are any questions, we have a little time for questions. And if there's anything else that you wanted to add, Shawnielle.
Nope. Just if anyone has any questions, we will get to those. All right. So generally, honestly, the only way that a spouse could get disinherited is if they signed a pre or postnuptial agreement agreeing not to receive anything under, the other spouse's estate. But absent that, they will generally receive something if you're not legally separated or divorced. So one thing is, you can't just walk away and separate. You do have to go through court process, at least file a legal separation agreement so they don't get anything. Otherwise, your spouse can come in years later. You might have been separated for 10, 20 years and claim part of your estate. Another thing also is like with parents. In some cases, you have parents that don't really take care of the child. And in that case, if the child dies and the child doesn't have a will, it can be a young adult, then technically the parents under intestate succession would inherit 50-50. But in Maryland, if the parent was not involved in supporting the child or did not hold the child out as their own, so they really didn't claim them, then they are disinherited if the other spouse would, point that out. Or not the other parent, excuse me.
Like I said, thank you all again for joining us tonight. If you have additional questions, or if you decide like, hey, I heard it, I've been waiting long enough, I'm ready to take some action and get started, please kind of take those steps. You can contact either of us, or if there's someone else that you have in mind. But either way, I would say don't put it off any longer.